My colleague Sabyasachi joins me live on the broadcast to give us more inputs on this. Sabyasachi, good afternoon. This is, of course, a setback for Manish Sisodia, but just to draw things into perspective for our viewers, talk about the allegations that was levelled in terms of this feedback unit that was set up by the Aam Aadmi Party.
Well, absolutely. See, it's a major setback for Deputy Chief Minister Manish Sisodia. And to simplify it for our viewers, this particular allegation has come in the year 2015 when the Aam Aadmi Party decided to open a feedback unit. Now, what was the purpose of this feedback unit? The purpose of the feedback unit is to give feedback from all the departments that are holded by the Delhi government. Now, the focus has been shifted. What the BJP as well as CBI in their preliminary report has stated that the focus of this particular feedback unit was on other political party, other opposition leaders. Now the BJP has stated that this particular feedback unit was focusing on snooping, was supplying information on opposition MPs, even union minister and other political parties. Now, this is the allegation which has come forth. Now, the CBI has started investigating this matter from 2017 onwards. Earlier, they had filed a preliminary report to the CBI. Now, in this particular preliminary report that the CBI had submitted to the LG, it is clearly mentioned that this particular feedback unit was used to provide information that are of interest to the Aam Aadmi Party, information related to MPs, information related to other political parties. And also, in the year 2015, when this particular unit was started, around 1 crore have been submitted. And the unit started functioning from 2016 February onwards to 2016 September 29. In this particular period, the CBI has found that around 1 crore rupees has been given to this particular unit. And also, cars like SUV has been provided. What the CBI has also found out that the working of this feedback unit has caused losses to the government exchequers as well, and the amount is up to 30 lakhs. Now, the investigation is focusing on the information that has been collected by this particular feedback unit, because the amount is less. Now, the personal information
Right, Sabyasachi, I'll have to interject you for the moment, but thank you very much for getting us those inputs on the story. Of course, we'll keep coming back to you to get the latest on that, but I also understand I have Geeta Luthra, senior advocate, joining me on the broadcast. Ma'am, thank you very much for taking the time out and speaking to us. Of course, my colleague Sabyasachi was talking to us about what the allegations are, but, you know, legally speaking, if you can explain the process to us.
So, normally when there is an investigation against a public servant, in this case, there was a preliminary inquiry and they seem to have found something against the allegations made. Then once there is a preliminary inquiry and they found something, the CBI now needs to get a sanction because he's a public servant. Public servant, insofar as persons who are authorized to investigate, it's under 17. But insofar as sanction is concerned, it is under Section 19 of the Prevention of Corruption Act. And I think what has happened is that the Lieutenant Governor has granted sanction in this case to continue with the prosecution. Now, that happens as and when there is the case of a public servant. This is sacrosanct provision, basically because you want to prevent public servants from not being harassed, not being made accused in cases unduly, and that a higher authority studies the material, has the entire material before it grants a sanction, and there has to be an application of mind. In this case, I believe Mr. Saxena, after looking at the documents, the Lieutenant Governor has granted a sanction, and that sanction should be under Section 19 of the Prevention of Corruption Act. Now, of course, further matter will go on aspects with regard to he having been called earlier, he will be called again. All that will take place. Now, various aspects will come in, arrest or no arrest. Normally, with the public servant, if he's been joining investigation, most likely, and I can't speak for the CBI, but most likely there is no arrest.
One of the accusations, of course, being that it was collecting political intelligence. How does one go ahead to prove that? Because if you talk about misappropriate use of funds, and of course, there's a trail of money that can be proved. But when you talk about proving these charges of political intelligence and snooping on the same, if you could explain to us legally, how does one prove those charges?
See, it's not going to be that easy. Ultimately, what you are alleging is that they have used information to target people. Now, they have said that funds have been used, people have been given vehicles, etc., in order to do what was an unwarranted spying on ministries and political rivals. Now, the fact is that all of public money needs to be accounted for. The expenditure needs to be accounted for. Now, if you're doing, and as Mr. Sisodia says, he was in charge of the vigilance unit of Delhi government, which is what I seem to see on first glance, then that vigilance unit may be saying that we were looking at cases of corruption and we weren't really trying to do it as a political vendetta or a political mileage. So there will be allegations and counter allegations. The fact is that CBI can look under the Prevention of Corruption Act, if it has a strong ground, to look at the utilization or misutilization of public money, which may have been for corrupt practices. Now, there are various provisions which cover that under the Prevention of Corruption Act. And I haven't seen exactly what are the allegations made, except that at the time of grant of sanction, sanction is normally granted under specific provisions of the Prevention of Corruption Act. And once sanction is granted, then the machinery gets into motion, and then a charge sheet can be filed. So that seems to be
Ma'am, when we talk about one of the... Right. Sorry to have interjected you there, but the fact that the unit also functioned without a judicial oversight. So how do you read into that? And if you could explain to us about when these sort of units are formed, is judicial legal oversight always required?
I don't think a judicial oversight's really required. You see, in investigation, in fact, the courts have time and again said that investigation and inquiry are the prerogative of the investigative agency. Now, which investigative agency? Was it the anti-corruption branch of the Delhi government that was the arm which was, as a result of which the vigilance department, because vigilance department can be there in every state and will be there as a central vigilance, even with the central government. And a vigilance department will look into corruption cases. Now, the question is, was it that the feedback unit of 2015, and it's a long ago matter, ultimately we are talking of 6-7 years ago. Sometimes you don't even have that much material for a defense of a 7-year-old matter, except that these will be part of public records. So it's most likely that they will be available. Now, whether you need a judicial overview, I do not believe that you need a judicial overview. Investigation, inquiry, the
Right.
courts have again and again said that these are matters of an investigative agency. Now, which investigative agency was the wing of getting these feedback units, and who were they giving feedback to, and how? Is it an extra constitutional authority, or is it a wing of the state which is in turn giving information to the
Right.
ACB or anti-corruption branch?
Geeta
Or
Luthra, I'm afraid that's all we
the
have, time for. But thank you very much for joining us on Mirror Now, sharing your perspective, and also legally speaking, bringing things into context for our viewers. But we leave it at that for the moment. Thank you once again.